Good morning. Thank you so much for joining Due Process Institute's third annual program, Two Views, in exploration of SCOTUS's criminal law docket. My name is Shannon O'Toole, and in January of 2018, I founded the Due Process Institute. My vision was a simple one: to create a bipartisan policy organization to preserve procedural due process rights in the criminal legal system through any means necessary: legislation, litigation, public education. We consider ourselves, first and foremost, lobbyists for the Constitution, and we employ lawyers from both sides of the aisle in order to get that done. We were one of the principal architects behind getting sentencing reforms added to the First Step Act, and then we worked tirelessly to get that passed into law. Because at the time, we realized two things simultaneously. First, that the proposed legislation was essentially a drop in the bucket considering the improvement our federal criminal legal system needs. But on the other hand, we also viewed it as the most likely candidate for passage through a divided Congress. And we were keenly aware that meaningful criminal justice reform legislation hadn't been passed in almost a decade. So we engaged in work on both sides of the aisle. That wasn't easy, and it certainly wasn't popular. But now, as a result of that law's passage, 3,416 people, including people serving life sentences, have had their sentences reduced as a result of our work. 1,661 people have been granted compassionate release, and thanks to a lot of pro bono legal efforts, that number continues to grow. Thousands more will also serve lower sentences by having their good time credits increased. These are people, not statistics. In the years since the First Step Act's passage, the Due Process Institute has carefully identified or created numerous other opportunities to push other criminal justice reform efforts, including the introduction of a bipartisan bill to abolish acquitted conduct sentencing in the Senate, the introduction of a bipartisan bill to remove pretrial federal detention for drug defendants, the introduction of a bipartisan bill to abolish qualified immunity, the introduction of a bipartisan bill to create Inspector General oversight of the Department of Justice's federal prosecutors, the introduction of a bipartisan bill to protect confidentiality of emails between the incarcerated and their attorneys, and many, many other efforts. But we aren't just lobbyists. We are also pursuing our criminal justice reform objectives through the creation of cutting-edge research and scholarship, as well as through the strategic filing of amicus briefs. Our mandate, our passion, to honor, preserve, and restore principles of fairness in the criminal legal system now, not another 10 years from now, now. In the past year alone, we have filed 18 amicus briefs, and thank you so much to the law firms who make that amicus work a possibility, because those briefs are mostly drafted by volunteer lawyers. But amicus requests are pouring in from across the country, and we've had to turn down some good ones, because we don't yet have the resources to say yes as often as we'd like. So if you or your law firm would like to be a part of our amicus efforts, we'd love to have you join us. Please reach out to me directly, and we'll get you involved working on the issues that you care about. But also, we need to do more than just have smart lawyers willing to pitch in pro bono efforts haphazardly. The criminal law needs a better approach. It deserves it. The people deserve it. In the materials we've emailed those of you who are watching this program live, you'll find our brief guide to SCOTUS's criminal law stuff. A portion of that covers issues other publications typically don't, like interesting criminal cases of note where cert is still pending. Of the more than half a dozen interesting criminal law cases we highlighted for deserving your special attention in this year's edition, not a single one of them received amicus support. Fourth Amendment issues, mens rea concerning drugs and guns, prosecutorial failures to disclose exculpatory evidence, perjured testimony. It's a lot of wasted opportunities to help get the changes we all seek, to fight back as a profession on behalf of the people. I know that we'd love to hire a permanent amicus writer on staff to not only be able to increase our ability to weigh in on cases where you reach out to us and ask us to, but to affirmatively watch the Supreme Court's docket and weigh in on those cases that need support in order to get heard, and to go even one step further and to review the lower court dockets and be finding the perfect vehicles for these doctrines that are so harmful and that we really need to push back against. And if you agree with me that we need to be doing that as a profession, I ask that you consider giving a donation to us or to our tax-exempt foundation, Clause 40 Foundation, who is also a sponsor of today's program, so that we can do the work that you know needs to be done. But now let's get to the program. The two Supreme Court litigators who join us this morning likely need no introduction to you all, but I've asked some very special guests of ours to introduce them anyway. Our friends in justice at Cozen O'Connor and Miller and Chevalier graciously sponsored this year's program, helping us to defray, in part, the cost of providing free CLE to lawyers across the nation. Our programs have always been free, and we hope to be able to continue that practice. And so we thank those who make that possible, including these two firms, and also those individuals who donated when they registered for this program. So thank you. Nicole Spritzen and Andy Wise are here to help us introduce Jeff and Erin. Nikki is vice chair of Cozen O'Connor's White Collar Defense and Investigations Group, and Andy is the chair of Miller and Chevalier's Litigation Department. Nikki, take it away.
For having me. It's my pleasure today to introduce Erin Murphy, who's one of today's top constitutional lawyers. After graduating from the Georgetown University Law Center near the top of her class, she started her career as a law clerk for Judge Diane Sykes in the U.S. Court of Appeals for the Seventh Circuit, and went on to clerk for the Chief Justice of the United States, the Honorable John Roberts. She then joined private practice, working with Paul Clement at King and Spalding, and then Supreme Court and appellate practice boutique, Bancroft PLC, for 5 years. 4 years ago, Erin, Paul, and others from their boutique firm joined Kirkland and Ellis when the firms merged. That's where she practices today. Erin has had the unique distinction of having a practice almost entirely dedicated to appellate work and having argued cases at the Supreme Court only in private practice, having not gotten to start with the government, which is a unique distinction in this particular field, as many of you know. In fact, she is one of only a handful of women who have argued all their Supreme Court cases in private practice. She argued her first case before the Supreme Court when she was only 33 years old, and has argued 4 to date, with a winning record. And she's argued dozens of cases in courts of appeal. She's also received virtually every Young Lawyer Award, named a Rising Star for appellate litigation by Law 360, named one of the nation's outstanding women lawyers by the National Law Journal, and recognized in many other, by many other publications and groups. Few women have established the record that Erin has established so young. She's been among an esteemed list of only 12 chambers-ranked women lawyers for appellate and Supreme Court practice for 5 years now. But best of all, Erin is no longer as alone in this club of women appellate and U.S. Supreme Court lawyers as she used to be. But perhaps most revealing of her significant accomplishments at such a young age is that Erin makes it a practice to listen to Eminem's Lose Yourself, heavy rap ballad before every oral argument. While she walked the hallowed halls of the Supreme Court as a clerk, Erin had the pleasure to share tea with Justice Ginsburg and swap stories with her colleague clerks who worked for the justice. And years later, she's had the opportunity to argue before the justice. Hopefully she'll share some of those experiences with us today. We look forward to the discussion between Erin and Jeff about their predictions about the upcoming term in the absence of Justice Ginsburg as well. I'll turn it over to Andy now, who will introduce Jeff Fisher.
Thank you, Nikki. It is indeed a great honor to introduce Jeff Fisher to you all. I imagine that he needs no introduction. Jeff is a professor at Stanford Law School, where he's also the co-director of the Stanford Supreme Court Litigation Clinic. He is also special counsel at O'Melveny and Myers. Jeff, after law school, clerked for Judge Reinhardt on the Ninth Circuit and then Justice Stevens on the U.S. Supreme Court. He is presently recognized as one of the country's leading Supreme Court advocates and impact litigators. And he's argued nearly 40 cases before the court, including a dozen in the last 4 years alone. This introduction, frankly, would have been a little bit easier 15 years ago. I could have talked about how in the first 5 to 7 years of his career, Jeff had been the architect of legal strategies that had resulted in systemic change in cases like Crawford and Melendez-Diaz, which led to a complete rethink regarding the Confrontation Clause and a defendant's ability to challenge the state's evidence. Could have talked about Blakely, a case in which Jeff began the court down the journey that really transformed the use of sentencing guidelines in both the state and federal systems. But now Jeff's accomplishments are really almost too numerous to cram into a 2-minute intro. So let me just mention a couple highlights from the criminal law realm. Last year, Jeff argued and won the case of Ramos versus Louisiana, in which the court barred the conviction by a non-unanimous jury, which was really a lasting relic of the Jim Crow era that had been designed to minimize the impact of Black jurors. He recently also prevailed in the case of Pena Rodriguez versus Colorado, which was a critical case involving the right to consider whether a juror's racial bias impacted a decision to convict. And Jeff's impact reaches far beyond the criminal dockets. He's brought landmark cases involving educational disabilities, women's reproductive rights, and marriage equality for same-sex couples. He's been involved in critical litigation involving the Second Amendment, campaign finance issues, and voter identification. Jeff has received countless awards and accolades for his work, but as I was preparing for this, one caught my eye because it is the rare instance in which an award undersells its recipients. Jeff was recently named one of the 100 most influential lawyers in America by the National Law Journal. That is a list that I think could have been pared down from 100 to 1. And I think there's a good chance that Jeff would have been on it. So it is really my honor to introduce him to you all today.
Thank you again, Nikki and Andy, for your firm support of today's program. And thank you, audience members, for being here with us. We're thrilled to have such a large audience today. Jeff and Erin, thank you so much for putting this on for us again this year. It's not quite as much fun as our yearly get together at the Willard, but hopefully by this time next year, we'll all be able to share lunch together again in person. And we're very grateful that you are willing to try to help us recreate that intimate and candid dialogue while one of you is in Washington, D.C., and one of you is sitting in California. Jeff and Erin, take it away.
Thank you, and I think that kind of says it. With our two perspectives, we're really on opposite sides of the country even at this point this year. So, but it's a great pleasure to be back here doing this, even if we're doing it in a slightly different format this year. It's been one of my favorite events to do for the past couple of years running. We've just, I think it's a great chance to have a real dialogue about some cases. And the court's got a little bit less on the criminal docket right now than they might in other years, but we won't let that get in the way of having hopefully a good, engaging, and interesting discussion for everybody about the cases, and just a little bit more generally about what the court's criminal docket, where it might be headed, due process issues, and all the many things that I'm sure we'll be seeing change, as we've been seeing a lot of things change at the court over the past couple of years.
Thank you.
Jeff and I thought we'd start, just that it would be kind of fitting, given the state of affairs at the court right now, to start by talking just a little bit about Justice Ginsburg and her passing and her impact on the court, but on criminal law in particular. As was mentioned, I was one of the many clerks fortunate enough to get a chance to meet Justice Ginsburg while I was clerking. She was always extremely gracious with her time to clerks, and she was there on the bench for every case I argued, and I'm guessing for at least most of the cases Jeff argued. It's always hard when anybody goes. It just changes the dynamic of the court so much in the questions. I think back, and I remember her questions from my very first argument. She was usually asking me kind of the uncomfortable questions, given the positions that I was arguing for were usually ones she wasn't wild about embracing. But I remember an exchange with her in my first argument leading to kind of like the big laugh line in my argument. So she and Justice Scalia were jointly the product of helping me remember that I was actually up there before an audience and people that were engaged and enjoying listening to it. So they will forever be two very memorable people in my mind in that amazing experience of my first time before the court. As I was thinking about Justice Ginsburg's impact on criminal law, I'll be interested to get Jeff's thoughts on it too. I think it's an interesting area because for as long as she was on the bench, I think there's fewer cases in the criminal law area that we think of as kind of Justice Ginsburg's big cases. I think one of the kind of biggest criminal cases that probably gets associated with her is a case in which she didn't actually author an opinion, which is Booker, because she was the critical justice who both voted that the sentencing guidelines were unconstitutional, but then joined a different majority to retain them in an advisory capacity. And in some ways, to me, thinking about that, it seemed like a little emblematic of how I think about Justice Ginsburg in criminal law, which is I think it's an area where it's a little harder to kind of pigeonhole her into being kind of pro-defendant, pro-government, pro any particular kind of way you might come at a lot of issues, particularly when it comes to kind of both substantive and procedural criminal law. I don't think she was kind of uniformly someone you could put in one box or the other. I think there are certainly plenty of decisions where I think of her as actually being a little bit aligned with Justice Scalia and some of his views on and kind of taking a little bit of an originalist historical approach to criminal issues. But then you can think about a case like Jones, the GPS case, where she was with the concurrence with Justice Alito that took a little bit more kind of pragmatic and a little bit less doctrinal and historical approach to Fourth Amendment issues. So I think in some respects, it'll be interesting to kind of think through. It's not as obvious when you think about some of those substantive and procedural issues to think about exactly how the loss of Justice Ginsburg and whoever the replacement may be will impact the direction in which the court is going, or impact the lineup in cases. When I thought about it, to me, the couple of exceptions to that, where I do think of Justice Ginsburg as having been, pretty much decidedly, and more often than not in one camp, are death penalty cases, and kind of particularly, in the context also, I think, of habeas more generally. And then also on the substantive area, I think she was probably a little less kind of defendant friendly in white collar areas than maybe a more conservative successor might be. And I think when you think about the death penalty area, though, it's also she's a justice who I think more often than not her vote was with the criminal defendant or the habeas petitioner or whatever posture it was arising in. But then she's a justice who I think kind of pointedly never went so far as to take a position on saying the death penalty was unconstitutional. And that again seemed kind of in keeping with how with what I think is overall a relatively even-handed approach in thinking about some criminal issues. But I do think for purposes of thinking about the Due Process Institute, which I think of as something that's both about criminal law, but also about criminal law and the broader kind of due process implications, I think of her as a justice who was probably particularly more a friend to kind of whether it be the criminal defendant, the habeas petitioner, the 1983 plaintiff, a friend a little bit more in that process capacity of the willingness of federal courts to look more closely at habeas cases, of the willingness to have a little bit looser conceptions of the imposition of liability for government misconduct in kind of the criminal context, a little bit more of a friend there than kind of a necessarily clear vote on where you were going to be on issues of the substantive and procedural issues. But very much welcome Jeff's thoughts, as he argued lots and lots of criminal cases before her, and I'm sure has lots of perspective on it.
Well, thanks, Erin. So before talking about Justice Ginsburg, let me just echo what Erin said about this event, which is it's great that we can go forward with it, and it's amazing that what Shanna has already put together with DPI in just a few short years. Like, this is an event that is kind of etched in my mind as a September or early October event that seems kind of like a date on the calendar, and I think that's really impressive, and I think it's neat that we can get together like this, and hopefully, as you say, next year we'll all be in the same room together again. As to Justice Ginsburg, there's so much that could be said, and so much that quite rightly has already been said about what an amazing person she was. As my colleague at Stanford, Pam Carlin, pointed out, she's one of the rare people who would have been famous and renowned even if she'd never been on the Supreme Court. And that's a pretty amazing thing to say about somebody who had such an incredible career on the Supreme Court on its own terms. One thing I think I'd pick up on that, Erin, you talked about is, and again, something that's been talked about a lot, but her relationship with Justice Scalia to start. And I think that particularly in the event we're having today and the mission that Shannon described for DPI, it's worth us just pausing and reflecting on that, which I think was just a model for so many people to say, I'm not always going to agree with this colleague of mine. In fact, we're often going to disagree fiercely, but it's never going to become personal. And in fact, we're going to enjoy each other's company and build a relationship of trust between each other. And that's just in such short supply these days in many ways. And so, as she leaves the bench, I think it's worth reflecting on that and just hoping that that other things like that will persist at the Supreme Court and, I would say in our judiciary and our politics beyond that in many ways. But that was, I think, a neat, important thing that we can all try to aspire to. In terms of her views and decisions on criminal law, I think it's fair to say that criminal law was maybe not her foremost passion when it came to the work of the court. But it was closely related to something that truly was a passion of hers, which was civil procedure. She was as many of you know, she's a professor of civil procedure and sort of just a fiercely engaged in that topic throughout her time on the bench. I don't know, Erin, if you ever argued, I argued one civil procedure case before about sort of what a rule of the civil procedure, and it was like it was terrifying. She was there sort of as the taskmaster all the way through. And thankfully for me, she ended up agreeing with my position, but even for me, that was just sort of terrifying to sort of get through that with her and not make a single mistake, which I did not accomplish. She pointed out a couple of places where I said things that weren't exactly accurate. But if you carry that over to the criminal law side, I think that was probably a good window into how she viewed criminal law, is a lot of the issues, which was just enforcing the rules of fair play. And so she did take, I think, a pretty legal, formal approach to some criminal law issues. And I think that explains her vote with the majority in Booker. In some ways, the Apprendi doctrine was something she believed in. I think she believed in the fairness of requiring the prosecution to prove important facts beyond a reasonable doubt to the jury. She was in the majority in the court's Crawford decisions for the most part and wrote one of them, Bull County against New Mexico. Again, as Andy said at the top, sort of a fundamental rule of fair play in criminal trials that she, I think, really believed in. And then maybe one of her most famous dissents was Connick against Myers, where she actually read from the bench. I think it might have been the only criminal law dissent she ever read from the bench, where she criticized a majority of the court for allowing prosecutors to get away with suppressing evidence in violation of Brady, she thought. And so I think those fair rules of the road were really important to her. And I think the last thing that I would say, though, is, that didn't always cut in the defendant's favor. Another one of my memories of arguing a case to her was a case I argued called Magwood about a decade ago. It involved it was a death penalty case from Alabama on habeas. And I was representing the defendant petitioner. And the issue was whether he should be barred from bringing a habeas claim on the ground that he had a previous opportunity to bring it in a previous habeas petition he brought. So the funny thing about the case is he prevailed in an earlier habeas proceeding, and then now was in a subsequent one challenging the result of the retrial, which had again put him on death row. And the state was making the argument that he shouldn't be able to bring a new claim in this second habeas petition that he could have brought in the first. And Justice Ginsburg, like much to my dismay at argument, really thought the state was right. And I so remember leaving the courtroom with just absolute pit in my stomach because I thought I had lost the case because I wasn't able to persuade Justice Ginsburg that sort of under a formal understanding of habeas procedure, the new judgment was in fact an entirely new thing. So this wasn't a belated claim. It was the first claim against this new judgment. As it turned out, we ended up winning the case 5-4 with Justice Thomas, who of course had not spoken an oral argument, writing the opinion for the majority. So I tell that story both just to sort of fill out the picture for Justice Ginsburg, and I think, Erin, you're right. She didn't sort of walk into the courtroom, I'm on one side or the other. But on the other hand, maybe for those of us who represent criminal defendants in our day-to-day work and really, are wondering where the court is going to head, the way that Magwood ended up does remind us that criminal law and the Supreme Court, isn't an ideological institution in the same way that we think about it or we fear, in some other areas. So, anyways, that's just kind of a reflection on that. Erin, I'll let you react to that if anything you want to, and then we can turn to the cases.
I will just note one thing it brought to mind, which is my other kind of great memory of indirect interaction with Justice Ginsburg, which was when I was clerking. The Chief Justice wrote the dissent in a 5-4 procedure. It's like basically civil procedure question. He wrote the majority, and I do vividly remember, not that you ever don't take really seriously that you need to get everything right when you're drafting a Supreme Court opinion, but boy, when you're saying Justice Ginsburg's wrong on a matter of civil procedure, it was a whole nother level of challenge. I still stand by our views in the case, but it was kind of like one of those great things, like when you're in law school and have that professor who will give you the really hard time you need to make you work that much harder. It was that experience, I think, for me, being part of chambers when we were put to that task.
That's actually a great story. I can just imagine the sort of trepidation of circulating that dissent and what was going to come back at you. Just like we all have when we file briefs and then the other side gets to respond. But yeah, that's great.
The classic thing where you're like, I think we're right, and I think we didn't really screw anything up, but who knows? Maybe she's going to tell us. We don't know. So it was fun.
Yeah.
Fun and maybe fun's the wrong word, but
yeah. She was really special.
Yep.
Well, I think we'll turn to some cases now. As Erin said, the docket is a little thin from the criminal law perspective at the moment. The court's filled out, just by way of its ordinary custom, it's filled out about half the docket for the allotment of cases it'll hear in this term. So there's still a lot of room for important criminal cases to be added for the second half of the term, or there are oral arguments in the second half of the term. And maybe at the end, Erin and I are going to talk a little bit about things we might watch for as the rest of the term unfolds. But we'll do a module now where we can kind of go back and forth and talk about the criminal cases, the noteworthy criminal cases that are on the docket right now and set for argument. And I'm going to start with a case called VanBuren versus the United States. And I will sort of confess at the outset that I represent Mr. VanBuren. So I'll do my best to give you the objective rendition, but maybe Erin's views will be all the more important in response here. And I'm probably going to spend a little more time on VanBuren because perhaps selfishly, I think the case is maybe one of the more interesting ones, even of the lot we're going to talk about. So anyways, VanBuren, I think of VanBuren as at least the next potential case in what has been a line of cases in the last decade or so from the court involving the problem of overcriminalization. And so if you look back several years ago, the court decided a couple of cases, Yates against the United States and Bond against the United States, where the court reversed criminal convictions, where it thought that federal prosecutors had stretched federal criminal laws sort of beyond the breaking point to things that really were best left to state authorities, or maybe no prosecution at all. And kind of famously, in the second of those cases at oral argument in the Yates case, Justice Scalia asked the Solicitor General, was it the same local prosecutor who brought this case as the other case? And so we really started to get wind that several justices on the court were really concerned with overcriminalization. And then a couple terms ago, we had a case called Marinello involving obstructing the due administration of the tax code. And the court said, I think in a unanimous opinion, that the federal government's construction of that statute would have allowed prosecutions for things like paying a babysitter in cash. And that can't possibly be the proper subject of federal criminal law. And then last term, just to finish setting the table, in the Kelly case, probably more popularly known as the Bridgegate case, the court again unanimously held that the mail and wire fraud statutes couldn't be stretched so far to cover, sort of political squabbling and malfeasance that didn't truly defraud individuals of property. And so the VanBuren involves yet another statute that is potentially quite broad, called the Computer Fraud and Abuse Act. And this law was passed actually in two pieces, in 1984 and 1986. And if you want, one little fun thing that I learned in this case as I researched the history of the law was that one of the real instigators was the 1983 movie War Games, featuring Matthew Broderick as a teenager in Seattle who hacked into the Department of Defense computer and almost started a nuclear war. Apparently, and this, I've read this in a few reputable sources, apparently President Reagan watched the movie at Camp David one weekend and then called a bunch of advisors together and said, "Is this possible?" And they said, "Well, actually, it's not quite as far-fetched as you might think. It might be possible." And that actually started a series of studies that resulted in this statute that, at its core at least, was designed to criminalize computer hacking. And the statute in particular makes it a crime to access a computer without authorization or to exceed authorized access on a computer. And so the VanBuren case is about that latter phrase, exceeds authorized access. And the statute defines it as accessing a computer with authorization and obtaining information that the user, quote, is not entitled so to obtain. So the question is, what does that phrase and that definition mean? And what we say in our brief is that basically the exceeds authorized access prong of the statute is just designed to criminalize inside hacking, kind of the same way that outside hacking is criminalized. In other words, if somebody has access to certain parts of a computer or a computer under certain circumstances, but is not allowed to access another part, a different database on the computer, so to speak, under any circumstances, then it violates the statute. So in other words, we say the person has to be categorically barred from accessing the information at all. The government takes a more expansive approach, and they say that that it's enough to be prohibited under the circumstances that you do obtain the information from doing so. So under any circumstance that would get in the way of your rightful obtaining the information, you should be found guilty under the statute. And so if you haven't quite grasped onto it already, let me explain to you why a huge amount turns on which of those two readings is right. So I'll start with the facts of the case of VanBuren. Lots of employers have what we might think of as use policies of computers or databases or information on computers. And so this case is involved as a police officer in a small town in Georgia who had access to a database for running license plates and getting information from that database. And the allegations in the case and what the jury found is that he was allowed under his work policy to access that database only to only for legitimate law enforcement purposes. But what he did instead was do a favor for a friend to look up somebody's license plate for no law enforcement purpose. And so, so violating employers' use policies would be a violation under the government's theory, but also so would a whole lot of other things. So just stick with employer use policies, really. One of the most common employer use policies that exists is that you're supposed to use your work computer only for work reasons, not for personal reasons. So as we say in our brief, if the government is right, then it would seem that, anyone using their work computer to do personal Facebook, personal email, to fill out a March Madness bracket, to shop on Amazon.com for a birthday, any of those things would be a violation of the CFAA under the government's theory. Also, terms of service on computers, that is on databases and websites. So one of the examples that we use, picking up from a Ninth Circuit case, is what about online dating apps? The rules of things like Match.com and their more recent equivalents are that you can't lie on a dating base. You can't lie about your age, your weight, your height, other features about your identity. But we know from studies that something like 80% of people do. And there's all kinds of other terms of service on websites, on things like eBay and Craigslist and Uber that you could immediately probably think of are sort of honored in the breach. And then finally, because I run a clinic, I turn to my students, and so we brainstormed a little bit, and they came up with a couple of hypos. We all use Westlaw, and we all have terms of service for the use of Westlaw. What if we used Westlaw to, or as my students say, what if they used Westlaw to get some information about local housing ordinances or rent control laws to negotiate their own personal lease? That would violate the statute under the government's view, or even surfing the internet in class. If the class syllabus said you can use your laptop to take notes, but not to surf the internet. If a student checks the weather during class, that would be a violation of the CFAA. So I've probably gone on here long enough with these hypos. You can tell we kind of had some fun with it. But I think that all of this sets, at least for me, the question of whether the court will continue to rein in overcriminalization. In the Marinello case I mentioned a couple minutes ago, the court said, we will not construe a statute on the condition, on the assumption that the government will use it responsibly. So one of the things the government says in its brief in our case is, look, we understand it's possible that the statute could reach all these given things, but we have a DOJ policy that we won't prosecute piddly little low-level CFAA crimes. That's not exactly true as an empirical matter historically, but even if the government really swore up and down, the court has been hesitant to accept those kinds of representations as enough to construe a criminal law in a broad way. And even though the court recently, it's kind of interesting, there's kind of two ships passing in the night in some ways, where the court recently has, for the most part as a court, really relegated the rule of lenity to kind of a true last resort canon that is very rarely invoked. It has in other ways kind of given it life in other ways in this overcriminalization jurisprudence, where the court has said something like, very much like the rule of lenity. We won't construe federal statutes broadly to cover everyday conduct unless Congress speaks clearly. And we won't construe federal statutes to tread on state prerogatives unless Congress speaks very clearly. And I think there's an additional thing the court might say in this case, we hope it would say, is that we won't construe an old statute really broadly if we don't think Congress really had any conception of what it would potentially cover with technological innovations. All the way back to, remember, this statutes from the 1980s, it's before we even had the internet. So the notion that Congress wanted to sort of create this vast, sweeping criminal federal law to police the internet, it's just implausible. And so hopefully that'll be another reason the court will kind of put the brakes on this expansive interpretation the government is pushing. So I'm curious to hear, Erin, if you have any reactions to that, and we think what you think the court do with it.
Yeah, I think it's a really interesting case. I have kind of two different ways that I naturally think of coming at it that pull me in different directions. Obviously having, as you know, I've worked on the Bond case, and I'm like very sympathetic to kind of overcriminalization arguments and federalism angles and all of that when it comes to kind of federal prosecutorial discussion. On the other hand, it's interesting to me that this question is arising, and I think it's super helpful for you that it's arising in the criminal context, because I've confronted the same question in the civil context, which I think is, my sense is like a number of the courts have actually decided it in the civil context, not just the criminal context, because the same statute, basically, the same provisions have a civil cause of action. And I think, I'm sympathetic. This seems like an odd prosecution. And I think the prosecution itself, very much has a flavor of what are the feds doing, kind of trying to set up like a goofy sting operation to catch local law enforcement. It's just, what are you doing? But at the same time, I think here this is, and maybe this goes back to, Yates was not a unanimous opinion. And here, I think the text of the statute is a little harder to reconcile with the idea that Congress didn't mean to capture the concept of exceeding the authorization you were given. And, I think the court will probably struggle with look, we don't want a reading of the statute that sweeps in everything, you know, the whole parade of horribles you're talking about. At the same time, is the solution really to interpret the statute in a way that seems to cut out things that it really does seem like Congress wanted to get at, that were not just, you know, completely unauthorized, you shouldn't be doing this in here at all, but exceeding the scope of the authorization you were given. And, you know, I expect that they will want to figure out a way that they can come at the statute that kind of reaches something in the middle. And, you know, it seems like you both kind of tried to offer some of that. And I suspect, you know, it seems to me that's where I would be, you know, focusing a lot of the questioning is, okay, you know, is there really a reasonable line we can draw? And it's also interesting because I think on the one hand, the case, you know, certainly fits into that kind of scope of, you know, appropriate scope of federal authority, prosecutorial discretion, all of that theme. But it also fits into, you know, sometimes I think about these technology cases as a little bit different bucket that, you know, isn't necessarily always a criminal thing. And here, obviously, you've got this rising in a civil statute as well. It actually puts me in mind of a case I'm involved in that the court's going to hear later in the term, which is the Facebook case about the TPPA, where basically our argument is, look, if you really have read the statute this way, like every time anyone in America makes a wrong number phone call with their cell phone, they'd be subject to $1,000 in statutory damages. And, you know, I think the court looks at some of these statutes and is probably very sympathetic to what you're, you know, the basic point of, look, like, you know, we really should not go out of our way to read statutes in ways that are going to accomplish things that are clearly not what Congress intended. But at the same time, you know, I think a lot of it is as much as they all want to not say they're not really like purposivists, and, you know, in a sense, I think they do want to arrive at something that they think is consistent with Congress's intent. And, you know, I think this case has, there's some reasonable arguments from my perspective on both sides of this.
Yeah, just one other thing that I think is really interesting that you pointed, that you get at is, you know, back when I clerked, you know, a while ago, I mean, there was still in an era where the court, I think, thought of itself as in more of a dialogue with Congress on statutory cases, that the court could issue decisions with comfort that if it got it wrong, or if it just created problems, Congress could sort of quickly react. And we've kind of lost that general feeling when it comes to statutory cases in the court in many ways and for many reasons. But I wonder whether technology might still be a little bit of an exception to that, and in a sense more like the old way of thinking. I mean, one interesting thing about VanBuren is that the Department of Justice itself has actually asked Congress a couple times over the last decade to amend the act to actually find a middle ground. And for whatever reason, Congress hasn't acted. But, you know, if the court were to construe the statute our way, I think it might reasonably think that, you know, Congress, this is actually one of those areas that isn't so hotly political, that Congress would step in, and rightfully so, kind of like it did in the Microsoft case a couple of years ago involving the warrant issue there, step in and update the US code for new technology. And that really seems like the way to get at some of these problems. I mean, just like Justice Alito pointed out in the Jones opinion you mentioned earlier.
Yeah, well, there's something to be said for kind of whichever way they resolve this. Like, boy, it seems like a statute that could use a little bit of updating to be a little more consistent and clearer about, you know, where Congress really wants that line to be. But I agree. I think it's one of the very interesting and more interesting kind of criminal cases that the court has on its docket this time. Which is not to undersell the case I'm about to talk about. But, well, you know, each year we've done this, like a lot changes at the court, and we've got new membership and so many things to grapple with. But it seems like one thing will never change, which is the court just like can't stop hearing cases about the Armed Career Criminal Act. So we've got some more ACCA on the docket this year, per usual. If you thought like Johnson was going to bring an end to this, you thought wrong, because apparently there's just as much division among the lower courts about the constitutional provisions of ACCA as there was back in the day about the one that has now been held unconstitutional. So the court this time around, the court's going to hear a case later this fall called Borden versus United States. That's about a circuit split over the elements clause of ACCA. That's the one that reaches a crime that has as an element the use, attempted use, or threatened use of physical force against the person of another. And the question here is whether that includes crimes that involve the reckless use of force as opposed to the intentional use of force. And so this case involves the petitioner was convicted of, he's a felon in possession, and the 3 previous convictions are all for aggravated assault under a Tennessee statute. And 2 of those are for intentionally or knowingly committing assault on someone, and then the 3rd is under Tennessee law, you can be convicted for recklessly committing assault that either caused serious bodily injury or involved using or displaying a deadly weapon. So his 3rd qualifying conviction is one of these recklessly committed convictions. And this is really, it's an issue that the court has kind of danced around for several years throughout a number of its cases, and probably most recently, the court reserved this issue in a case called Voisin that they heard, I guess it was about 4 years ago now, I think. And Voisin was not an ACCA case, but it involved a pretty similar question. It involved the felon in possession, the unlawful possession statute, the federal unlawful possession of a firearm statute, and it involved in particular the provision of it that makes it a crime for anyone who is convicted of a misdemeanor crime of domestic violence to possess a firearm. And there, the federal statute defines misdemeanor crime of domestic violence to include any domestic violence misdemeanor that involves the use of physical force. And so the question in Voisin, similar to the question here, was whether that included recklessly using physical force to cause bodily injury. And the court concluded that it did, but did drop a footnote in the case saying that it wasn't still resolving this question of whether it would reach the same conclusion when confronted with that question under ACCA, which has similar but not completely identical statutory text. So in keeping with the kind of the view of the court, as I think Justice Kagan put it, that we're all textualists now. Basically, we've got two textualist arguments here. One side, on the Voisin team, basically the petitioner, the argument is this is really not any different from Voisin. The government says, it's use of force. Voisin said the use of force can include the reckless use of force because reckless is more consistent with knowing or intentional use of force. And that's really kind of what puts you on the side of mens rea. We can put all of that to one side, and really it's kind of negligent or accidental uses of force that shouldn't be covered by the phrase use of force. The petitioner, by contrast, says the real focus here should be on the part of the statutory text in ACCA that says not only that you have to use physical force, but that you have to use physical force against the person of another. And the petitioner says the key phrase here to focus on is against the person of another, and that phrase brings in a more direct concept of use of force, and really is getting at the idea that you have to have not recklessly used force in a way that harms someone, but have actually directed the force at another person, and that you should understand that to mean that for purposes of ACCA, the use of force necessary needs to be intentional or knowing use of force, not reckless use of force. So I think this is really, it's interesting to me that it ends up being both sides just saying, we've got the better of the textual argument, and you just got to focus on the right text. They both really kind of have their key case, and for the government it's Voisin. For the petitioner, it's, they go back to the Leocal case, which you may recall from a while back was the case where the court said that drunk driving convictions don't fall within the elements clause because they don't involve, whether you would say it's because they don't involve intentional force, or you would say it's because they involve negligent or accidental use of force, is kind of part of the question here. But the petitioner says this is more like Leocal, and really the right place to draw the line is intent versus negligence or accidental force. So it'll be an interesting one, and an interesting kind of where which side of the text we think is the controlling text. You know, it seems to me, I do think Voisin makes it, you know, a little bit of an uphill battle here for the petitioner. You know, I think the best argument they can make is that there is some different statutory text here that points in another direction. But you know, when you look at the footnote in Voisin that reserved this question, it sort of reserved it in a way that felt a little bit more like we're reserving the question, not like we're reserving it and here let us explain why there's a lot of reasons we think we might reach another conclusion when it ultimately comes time to resolve it. But time will tell.
Yeah, so you know, ACCA certainly is the gift that keeps on giving. So far be it from me to disagree with Justice Kagan if she tells us that they're all textualists now. And I do think she's right, and I certainly, as a practitioner, follow her advice when it comes to writing briefs to the court and making arguments. I think everybody sort of understands now that the first thing you need to talk about is the text, and you need to really, really dig into it and really think about it hard on a definition of each word and the linguistic indications of meaning and whatever else. That said, I'm still somebody who thinks, just as I look at the court and its decisions, that not all decisions actually are based on text, and most often just for the fundamental reason that I think the text sometimes just ends up indeterminate. And so if that is true in this case, Erin, I'm curious to get your view on one thing, which is, you know, the other way to look at this case is about how important is mens rea, right? And the court a couple of years ago, and one of the most striking decisions in criminal law in recent years, issued a decision in a case called Rehafe, where it disagreed with every lower court to have decided the issue and held that the illegal possession of a firearm statute required not just mens rea that you had the firearm, but that you had the status that made it illegal for you to possess the firearm. So in that case, it was immigration status, but most often it's felon status. And I think that was 7-2, if I'm remembering correctly. And so, you know, so you could get a signal from that decision that the court really cares a lot about mens rea. On the other hand, you know, maybe there's a difference in a case like that where it's an on-off switch between mens rea. It's either strict liability or there I think it was knowingly, because that's the mens rea in the statute. And maybe in a case like this where it's just sort of, you know, a gradation question about whether recklessness is enough, maybe they would approach it differently. But I'm curious what your views are. Like, do you think the court is bullish enough about mens rea that just, you know, to whatever extent sort of policy and just sort of their own view of good common sense enters into it, that they'll have pause about a reckless mens rea?
Yeah, and I do think, like, kind of, to me, the lurking question in all this that's sort of more interesting than even just thinking about the text is that question of, like, do you really want to say recklessness is just clearly on the okay versus the not okay side of the mens rea line? I'm not sure that that's something the court has kind of definitively taken a position on. And, you know, I tend to think here that what perhaps ends up being a little more persuasive and easier for the court for purposes of resolving this case is, I thought the government made a pretty good argument about how, if you really understood this to not include recklessness, you'd be taking outside the scope of the elements clause some crimes that clearly are supposed to be, were intended to be within the scope of the elements clause, most notably robbery, which can involve the reckless use of force. And they kind of made an argument about, you know, murder not falling within it in a lot of contexts. And I wonder if, you know, some of that might be the easier way for those who are inclined toward the government's position to latch onto it and go with it and think of it more as a statutory interpretation text intent matter than really definitively put themselves on one side or the other of that ultimate question of where, you know, if recklessness is good enough for mens rea as a general matter. Interesting.
Well, that'll be another one to watch. So turning to another case, I think this is our 3rd out of 5 we're going to highlight. I'm going to introduce you all to Jones against Mississippi, if you aren't already familiar with the case. So we're moving now from, you might think of substantive criminal law into, this is sort of constitutional criminal procedure, or this is an Eighth Amendment case, so maybe it's sentencing, whatever. But the issue in the case arises out of the court's recent string of cases under the Eighth Amendment, curbing the ability of states to impose life without parole on for juvenile offenses. And in the court's most recent couple of cases, the court has said that even when you're dealing with a crime as serious as murder, states cannot have mandatory life without parole sentencing. The most recent decision there explained in the decision that because of the sort of underdeveloped juvenile mind, courts need to ask themselves in each particular case involving each particular defendant whether that person is truly, has, in the court's words, is permanently incorrigible or has some chance of rehabilitating many years down the line and safely being released from prison. And so the issue that arises in Jones is whether that permanent incorrigibility discussion in the court's most recent cases actually sets up a required finding to impose a LWOP sentence, or whether, as Mississippi claims, it's enough for a judge simply to just give an individualized consideration to the defendant without making any particular inquiry or finding, and then impose whatever sentence the judge thinks is correct. And so a couple of interesting things about this case that in some ways kind of rise beyond that issue of juvenile punishment, which is of course important in its own right. But a couple things that kind of get us thinking, maybe one of these cases is termed, that get us thinking about stare decisis and the court's approach to precedent in general, and then as the membership shifts. Because I think that if you look at the couple of recent cases, probably Jones has the better of the reading of the recent cases that seem to suggest that that it's not enough just to sort of announce I'm giving an individualized consideration, that the judge really does have to make some kind of finding that this juvenile cannot be rehabilitated, and again, to use the court's term, is permanently incorrigible to impose the LWOP sentence. But there's a couple of things about that about that language in the court's cases that still make it an open issue for the court. So one is that that wasn't. I mean, there's a debate about whether that was required to explain the prior decisions the court has handed down, but at least the state has a plausible argument, I think, that it wasn't necessarily required that the court decide that issue in the prior cases. And indeed, one of the interesting things that the Solicitor General says, who defends, who's siding with the state of Mississippi, is, if that were right, if you did have to make a finding of permanent incorrigibility, then that finding would seem to be subject to the Apprendi doctrine, because it would be a finding that exposed the defendant to a heightened sentence that was necessary to impose that heightened sentence, and so this case puts on the court's radar, I think, not just how it feels about the court's Eighth Amendment jurisprudence in this area, but also how it feels about the Apprendi doctrine, because a holding in this case might have implications for that doctrine. And I think that brings us back to this interesting thing about the shifting membership of the court, and not so much with Justice Ginsburg being replaced by a Justice Barrett or whoever it might be, but going back to the prior replacement of Justice Kennedy being replaced by Justice Kavanaugh, because Justice Kennedy was the fifth vote in all of these juvenile punishment cases. I say all of them. I think there may have been one or two that had a broader majority, but each of the significant moves in the case law were 5-4 decisions with Justice Kennedy in the majority. And so I don't know that we know Justice Kavanaugh's views on this issue. I don't know that from the DC Circuit body of work that he put together whether we can really say what he thinks. But if Justice Kavanaugh sides with the more conservative members of the court who don't think this area of law really has a firm grounding in the Constitution to begin with, one would imagine that the court might begin to sort of stop this jurisprudence in its tracks. I'm not sure the court would want to, or much less need to, roll it back, but it certainly might not push it forward if Justice Kavanaugh is unsympathetic to it. So, I think, and as I said, also now with Justice Ginsburg being off the court, who is often a fifth vote in the Apprendi line of cases, her replacement, if the case ended up being argued to a 9-justice court or one way or another, a 9th justice was part of the decision, views about the Apprendi doctrine and potential expansions of Apprendi could also be worth watching with the new justices.
Yeah, this case, that it raises for me exactly the question you've asked, which is you look at it and it just could very much fit into that dynamic of, is the current court, whatever its membership may end up being, as fully bought in as the majorities that produce some of these cases. And I think, as a former chief clerk, I always am interested to watch the chief, but I think he's an interesting one here because if I'm remembering the sequence of this all correctly, I think he was kind of with the dissenters in earlier decisions, and then I think he was was a 6th vote in Montgomery, but was a 6th vote, and the 5 without him required both Justice Kennedy and Justice Ginsburg. And so, so this is certainly a line of doctrine that I could see there not being the same support on the court to be looking to kind of extend or expand, or whether it's fair to view it that way or not. Yeah. So, I do think it'll be definitely one of the cases where the multiple changes in membership over the past few years could make a real difference.
Yeah, and you're totally right to point to the Chief Justice too. I think that I talked about new members and such, but the Chief Justice will be fascinating to watch here. I mean, one of the cases I was involved last term was the June medical case about abortion rights, and I think many people know he wrote a separate concurrence for himself that was really fascinating in terms of his view of stare decisis, which is he sided with the more liberal members of the court to invalidate the law, talking about stare decisis and saying, this case is controlled, the outcome of this case is controlled by our previous precedent. And even though I dissented from that previous precedent, I'm going to now join this new decision enforcing it. At the same time, the Chief Justice said there's language in that prior precedent that I think went too far and was not consonant with the earlier jurisprudence and my understanding of what the Constitution really requires. And so in a way, he sort of cut back on some language, I think the way he would put it, some language on the prior decision that he thought went too far, which is kind of a different approach to stare decisis. And some of those same dynamics are kind of present in this case, like if you look at it, right?
Yeah, it is literally what had popped into my head as you were talking about it. I think there's some really interesting parallels, and fairly or not, and maybe it is fair. I think there's a lot of belief that the Chief Justice kind of will make decisions about where he is based on what impact it can have on where the ultimate opinion of the court or the ultimate holding of the court. And this certainly seems like a line of jurisprudence where you could look at his kind of most recent vote in this area as sort of consistent with that dynamic. Mm-hmm. I think if we really, particularly if we end up having a Justice Barrett soon, there's a lot of cases that I think will put a fine point on whether that theory is true and how true it is, and if he operates differently, if there's sort of six justices leaning a little more conservative, and this seems like one of those cases that could be interesting for purposes of studying that question. So continuing with some criminal procedure questions. We talk a little bit about Torres versus Madrid, which is just a great Fourth Amendment case. I think it has a really interesting question presented, but also think it has just a kind of a great fact pattern that leads to all of this. So I'll tell you a little bit about the case to set up how we got where we got, and got to what seems like a little bit of a peculiar question to me that for the court to be resolving, but ultimately an interesting one. So this case started when some New Mexico police officers went to serve a warrant on a female suspect who was not, as I understand it, the actual woman who ends up being the petitioner in this case. But they get there to serve the warrant, and there's a little bit of lack of clarity about whose story exactly is right, but one way or another, there's a woman who's in a running car, a little bit of suspicious activity going on. So they're in tactical gear. They go to approach the window and ask her to stop and ask her what she's doing, who she is, whatever it may be. At that point, the petitioner here, who by her own account was suffering from a few days into meth withdrawal, said she freaked out. She thought the officers were carjackers, so she puts the car into drive and basically guns it. The officers say they think she's trying to run them over, and they're in tactical gear and approaching her in their capacity as police officers. So they start firing at her. They fire several shots. They end up hitting her twice, but she's able to keep driving, and she keeps driving and drives for a while and gets to a parking lot where she asks somebody to call the police because she's worried these carjackers are following her, but she doesn't want to stick around because she's got some outstanding warrants. So she then steals a car from the parking lot and manages to drive 75 more miles to a hospital where she's ultimately she's actually airlifted to another hospital and treated for the gunshot wounds that she suffers. She's arrested the next day, and she pleads no contest to a bunch of charges, fleeing from the law enforcement officers, assault on a police officer, all in connection with this kind of fleeing from the police. Then 2 years later, she brings a 1983 action against the officers, alleging that they used excessive force in their efforts to detain her. Now, I look at this and think, there seem to be like any number of ways a court probably could have ended up dismissing those claims if you accept what the officers are saying here is true. But the district court and the 10th Circuit end up dismissing them on the ground that there was no seizure within the meaning of the Fourth Amendment, because while the officers shot at her and successfully shot her, they didn't succeed in stopping her, and she was able to get away. And so the question that ends up coming to the court is whether an unsuccessful attempt to detain a suspect by using physical force is a seizure, or whether you only have a seizure if the physical force actually succeeds in stopping the defendant. It's just kind of one of those questions that like only the Supreme Court can end up answering. It feels kind of like a law school exam type question. And it's really interesting briefing. So the petitioner basically has, what seems like a rather common sense rule to me, which is that if the officers can try to seize someone in two ways. One is by a show of authority, telling the person to stop or telling the person to submit, or the other is applying physical force with the intent to restrain someone. And they really ground it all in a common law argument that at common law, the common law arrest doctrine, those were kind of the two ways to accomplish an arrest. And they rely heavily on a Supreme Court case called Hodari D, which is actually not a case I have been familiar with, but maybe because this question doesn't come up a whole lot. But their principal authority is a case called Hodari D, where the court had basically articulated the rule for seizure as the use of force to restrain movement. The respondent says, no, the right rule really is that you have to actually succeed in detaining the person. And they've got a case, a couple cases on their side. The principal one seems to be a case called Mendenhall, where the court described seizure as the use of physical force or a show of authority that ends up with the freedom of movement being restrained. Looking at some of the language they use, it's not entirely clear to me that the language from the cases that they're relying on is actually consistent with the idea that you have to actually stop the person, as opposed to consistent with the idea that the real test is whether the force or authority that you've used is sufficient to restrain someone if you're successful in using it. But basically, the debate becomes about whether historically you need that use of force. There's a couple of interesting things on the amicus front here, I think. One is that the United States is participating in the case in support of the petitioner. And they agree that that the rule should be that the the use of force with the attempt to detain somebody is sufficient to constitute a seizure, and that it doesn't matter that you didn't successfully detain the person. The concept that both petitioner and the United States talk about that I find like a little hard to grasp is, they both seem to be conceding that what you have is like a fleeting seizure, because the seizure doesn't continue once you're able to get away, yet the bullets have kind of done the seizure. And respondent says, look, what are you identifying as the end of the seizure if you've still got the bullet inside you that is purportedly of what created the seizure? But they both offer the rule that, again, seems like kind of just a sensible rule, setting everything else aside, that it would make sense that the Fourth Amendment would apply in the same way to the amount of force that you can use to try to effect a seizure, whether or not it succeeds. I do think there's an interesting amicus brief on the respondent's side, though, that really probably grapples a little bit more with the history and the common law principles than the petitioner's, than the respondent's brief itself. This is a brief from the National Association of Counties and kind of all the municipal type organizations that that often are together on amicus briefs in these cases. And they make the argument that the historical rule about the use of force being enough to constitute common law arrest was really actually not a rule about common law arrest, but instead was actually just a rule that was used to decide whether, if an officer was trying to stop someone and then they retreated into their house, whether they were allowed to follow them, basically. And they say that really this was just a doctrine that was designed to say, even though there hasn't been a seizure or an arrest, we're going to say there's been a constructive arrest if you've kind of used some degree, however minimal, of physical force against the person before they retreat into their house. So I think it creates, it does create some ambiguity and some room for some questions about that what that historical test was, how exactly it all maps on, how exactly what exactly degree of force is used. I mean, I think at common law, it may have been a little less clear that the rule really was what I think the petitioners here are actually advocating for, which is kind of a objective, what would be objectively understood as force that was used to restrain somebody. So, I think it'll be an interesting question, interesting case, because while, I'm sure there'll be some justices who very much approach it from that historical perspective and thinking about, how are we going to map this on exactly to concepts of common law arrest and all that. I do also think this is one of these constitutional questions that has a certain element of like, can it really be right that as long as you don't succeed in stopping the person, the Fourth Amendment has just nothing to say about the degree of force you can use, even though when everybody knows what you were trying to do was seize someone? It all kept making me think, it feels like it would be so much cleaner if there were just some sort of intended seizure doctrine to invoke here. Apparently there's not, which is what makes this more complicated. But in all events, I think it's a really fun case, a really interesting one. And, I think the court will probably find it fun and interesting to deal with, although I'm not sure at the end of the day that it'll be, a super close call on the ultimate resolution.
Yeah, no, that's a great explanation. And yeah, it makes me think of could Bruce Willis in Die Hard, maybe he's just cannot be seized, or somebody who's, something like, so it is, it also reminds me of the Manuel against City of Joliet case a couple of years ago, which was another Section 1983 case involving a Fourth Amendment claim, and did it really fit within the Fourth Amendment or not? But if it didn't fit within the Fourth Amendment, it sure seemed like it should fit somewhere in the Constitution. So the court kind of grappled with that. And so, the other thing about this, though, that I'll just say quickly is, you said, there is a sort of fun legal nerd way to think about this case, but there's also a sort of deeply serious way to think about this case, which is the conversation we're having in the country right now about police practices, in the wake of George Floyd and Breonna Taylor and so many other tragedies, and the conversation about qualified immunity and all these kinds of things going on, where the court has basically not taken any of those cases. It's certainly denied cert in all the cases asking it to directly to reconsider qualified immunity. And I don't think it has a case on its docket that you could think of as sort of a race and policing case right now. And this is as close as it gets. And so I think it'll be interesting to watch whether the court in oral argument tiptoes, and I think it probably would be a tiptoe. I don't know that I'd be surprised if any justice directly tied all this together, but it will be, I think, important and interesting to watch and see whether the court is somehow being influenced by current events in a case like this.
Yeah, and I do think, you know, in a different dynamic, I could see a number of them wanting to kind of press on, look, even if you're right about this, petitioner, you should lose at the end of the day, which is really the federal government's position. They made crystal clear, you know, we're not saying she should prevail on a 1983 claim here. I wonder if the court will, you know, there's no really need for them to get into that anyway, given where the case is, but I wonder if, you know, some of these dynamics will make some of them a little bit less likely to just kind of ask some of those tough questions of the petitioner than otherwise they might in a little bit different dynamic.
Yeah.
We'll see.
Well, I'm going to mention one case very quickly because I want to make sure, Erin, you and I have maybe a minute or two to share any other sort of broader thoughts. And then I know Shannon wants to be able to ask questions from the audience. But just to sort of lay out for you the last case on the docket that you might want to watch is called Edwards versus Vinoy. And this is a case the court granted shortly after issuing its decision in Ramos that held that the non-unanimous jury verdict laws in Louisiana and Oregon were unconstitutional. And so right away, the court picked up a case to decide whether that holding is retroactive under, at least in federal habeas cases. And so I think the interesting thing about that is just, tells us something about Ramos itself, which was one of the arguments in that case. Remember, we were asking to have an old case overruled, Apodaca, and the court 6-3 was willing to overrule the old case, whereas the three dissenters didn't defend it on its merits, but just said as a matter of stare decisis, they would have stuck with the old case. And one of the back and forth in the case was about the reliance interest that these two states had in sort of thousands of convictions they had procured of individuals still incarcerated under non-unanimous jury verdicts. And the argument we made in that case in Ramos was, well, you have a separate jurisprudence, the Teague jurisprudence, already in place that is designed to accommodate proper reliance interests on past convictions. And that's kind of what Justice Gorsuch repeated in his opinion for the court. And so now, you know, we have the reliance interest sort of squarely presented through the lens of the Teague doctrine here. And I think there are, you know, as these cases go, I think everybody knows the court is extremely resistant to finding that new rules of constitutional criminal procedure are retroactive. But the court has always held out the possibility that it would say that something is important enough and fundamental enough to be what the court has called a watershed rule. And, you know, I think that there's pretty good argument that if that thing does exist, you know, the requirement of unanimous verdict really does meet that test. It is grounded in hundreds of years of common law aimed at procuring accurate verdicts. And so I think there's a you know, very serious argument, at least in this case. And so it'll be interesting to watch how the court reacts to it. I don't know, Erin, if you had anything else about Edwards, but I'll stop there.
Yeah, we're kind of getting close on time. So if we want to move so we can answer a question or two, if anybody has any, we can certainly do that. But while folks are getting questions, I mean, if we can both kind of offer a few just general thoughts. You know, I mean, I think it's funny. I feel like, you know, in the time we've been doing this, like every year, the court's kind of radically changing in ways where you keep thinking, and maybe this year we'll learn a little bit more about what the new court looks like, and then there's another new court. And you know, one way or another, we're gonna have another new court soon, and I think that makes it all a little premature to kind of know what that new court will look like. But I do think it. You know, I think realistically what that ends up doing is having an impact just in general on the cases the court takes and how quickly they get to issues. And I don't expect that to be any different in the criminal context. You know, I think that there's obviously just some things that get to the court in a way where they can't help but deal with them. There's also some issues that are, you know, that I think they feel comfortable taking, whether they've got 8 or 9 or whatever the dynamics are. You know, I mean, I think there's some circuit splits that it's just easy to take up, and they're kind of the things the court loves to be able to do and be able to show that they're still doing, show that the court can do, even as it's dealing with changes in membership and technology and all the many things that are, making their lives a little more difficult these days. But at the same time, I do think all that, means we're less likely to kind of see real blockbuster doctrinal changes in criminal law kind of anytime soon. And also because I do think, one of the reasons this is it's a fun event and a fun area to practice in and to study and look at each year is that it just really isn't one that lines up doctrinally in some clean way. And I think, the justices, just like advocates, they like to have a sense of where they think their colleagues are going when they vote to grant cases or deny cases. And I think it's going to take a little time for everyone to figure that out, because I just think, whether we have a Justice Barrett or whoever it may be, like it takes these aren't issues that always fit kind of neatly into whatever jurisprudence you come to the court with. And so I think that too may kind of impact the court's willingness to kind of dive right into some of these areas. There's actually other areas that, even though may be more controversial, may be things they get to faster, just because I think there'll be things where they have a better sense of where everybody's footing is. So I don't know, maybe I'll be proven wrong, and next year we'll be sitting here talking about like the most blockbuster, biggest criminal docket the court has had in years. But I could see it being an area where they take a little time to figure out where things are headed, and who's kind of where on the many issues going on here.
So those are great comments. And so in the spirit of the event, I want to agree with you, but also I think maybe take a different view to some degree, which is I definitely agree, as I think I said earlier, that this is an area that doesn't line the justices up typically in an ideological fashion. But actually, for that reason, my instinct is that we're actually see the court taking more criminal cases, not less. And maybe you're right about not big, giant blockbuster cases, but sort of workaday criminal law cases like the ones we've talked about today. I would expect actually, and maybe hopefully we can do this event a year from now, and so we'll see who's right, we'll see if I'm right. But I think there'll be a higher percentage of criminal cases on the court's docket, at least in the short term. We've talked so much about whenever you have a new justice about the rule of 5, that it takes 5 justices to announce any substantive decision, obviously, and change the law. But we don't talk as much about the rule of 4, which is the rule of 4 justices to grant cert. And one big change, if Justice Barrett is confirmed, will be that there will no longer be 4 Democratic appointed justices, or 4 what we might think of as liberal justices, to grant cert in any given case. They no longer have the power to force a case onto the court's docket. And put another way, they're going to be forced to be looking for compromises even at the cert stage and cert docket of the court. And I think for the reasons we've talked about, where you have an area of law that isn't so ideological and they can often agree on broader principles together, I think you might have justices more prone to vote to grant in criminal cases. Now maybe you're right also that there's sort of certain agenda items of the more conservative justices that are also going to be put on the docket. But anyway, that would be my prediction for criminal law.
And I could definitely see a world in which there's more cases, but they leave some of the big ticket things, for a little bit more time. But yeah, we'll see. I'd love to see the court, they take fewer white collar cases. They take them in this kind of when they arise in that context of kind of like over prosecutorization, but they seem to take fewer of them. And I as a practitioner, I fear a lot of it's because of the annoying habit of the Second Circuit to hold that everything is harmless error as a backup, so that every case ever is a bad vehicle, but there's a case up this year that actually presents a question about kind of that. So it'd be interesting to see if the court ever kind of reached out and because it is a way that it kind of prevents some of these cases, because so many of them do come out of that circuit from getting there. And it's an area of the docket, the criminal docket, that I could see being impacted by a shift in membership.
Thank you both so much. I wanted to pick up on something from Jeff's introductory remarks about bipartisanship and our mission here at the Due Process Institute. Our office has some eclectic modern art on its walls, and 2 of our pieces pay homage to our favorite Supreme Court justices, both of whom now have unfortunately passed, Justice Scalia and Justice Ginsburg. We pay homage to them on our walls because their genuine friendship, despite significant ideological differences, is the exact model our bipartisan criminal justice reform organization aspires to. We look past our differences to work together on our shared common values. And despite the bitter rancor of the current day, we wanted to remind all of you that progress and stability are ahead of us all if we continue to remember what unifies us more than what divides us. Thanks again for joining us for our program. Go forth and do good.